Today, we are dialing it all the way back to 1992 to a really fascinating court case. It pitted a telecom giant against a bold new challenger. And this was a battle over technology, sure, but it was also about the meaning of a single word, and really, the future of communication. It's a fight that, believe it or not, still echoes in our super-connected world today.
So at the heart of this whole legal showdown was one central, almost kind of wild question. Could a law that was written for underwater telegraph cables back in the 1950s actually be used to stop a company from handling international phone calls in the 1990s? I mean, that was the core of it. Old law clashing with new technology. All right, let's set the stage here. On one side, you've got the established giant, the Philippine Long-Distance Telephone Company, who we all know as PLDT. And on the other side, the challenger, Eastern Telecommunications Philippines Incorporated, or ETPI. And what were they fighting over? They were fighting for the gateway to the entire world.
Yeah, the whole fight was over this thing called an International Gateway Facility, or an IGF. Now, the easiest way to picture this is to think of it like an international airport, but for phone calls. It is the one critical spot where all international calls land before they get routed into the local network, and it's where all our calls take off to go out.
So, back in 1987, ETPI decides, hey, we want to build our own airport for phone calls. The problem? At the time, PLDT basically owned and controlled all the major airports. So, seeing this as a major threat to their dominance, PLDT immediately filed a legal opposition to block ETPI's application, and that, right there, kicked off a 5-year legal war.
So how in the world did PLDT build its case? Well, their legal strategy was actually pretty straightforward. They decided to argue for a very strict, very literal reading of the law. They were convinced that ETPI's own franchise documents held the key to stopping them dead in their tracks.
PLDT's entire argument really hinged on this one distinction. They argued that ETPI's franchise was for telegraphy, sending recorded messages like telegrams. Telephones, they said, are totally different. They transmit live voice conversations. So, according to PLDT, these were two completely separate technologies, and ETPI was only licensed for the old one.
And, if you look at the history of the franchise, you can kind of see where they were coming from. It all started back in 1952, specifically for a submarine telegraph cable. And even though it was updated over the years, PLDT's argument was that its DNA, its very core, was rooted in data, not voice. They basically said ETPI was trying to run a telephone business without a telephone license.
And what's wild is that the Supreme Court's majority, they actually agreed. They bought PLDT's narrow definition. They ruled that, in the context of this old law, the word message just meant a recorded piece of data, like a telegram, not a live phone call. It's just incredible to think that the definition of a single word was at the center of this whole thing. But PLDT's argument wasn't just, dry and technical. It was emotional, too. They painted ETPI as this freeloader, trying to ride piggyback on the massive, super expensive phone network that PLDT had spent decades and billions of pesos building. They said ETPI just wanted to swoop in and cherry-pick the most profitable part, the international calls, without doing any of the hard work. Okay, but ETPI wasn't just going to take that. They had a really powerful counter-argument of their own. Their whole point was that their franchise wasn't some relic of the past, it was intentionally written to be future-proof. And their entire case really came down to this one golden phrase in their franchise documents. It said they could operate systems by any other means which in the future may be developed. For them, this was a slam dunk. They argued this language was put there for exactly this kind of situation, for technological progress. They weren't breaking the rules. They were using the franchise exactly as it was designed. The dissenting justices on the court totally backed them up on this, but with a scientific argument. They pointed out that, look, on a technical level, this whole distinction between a voice call and a data message, it's meaningless. Both of them travel through the cables as the exact same thing, electronic impulses. The difference only matters at the very beginning and the very end, not in the middle. And Justice Feliciano, in his dissenting opinion, he did not mince words. He called PLDT's whole argument bootstrapping or self-levitation, which is a fancy way of saying it's a circular argument that pulls itself up with no real support. He said it had absolutely no legal or other basis. I mean, that is a scathing critique of his own colleagues' reasoning.
So you've got both sides presenting these compelling but totally opposite arguments. The case then went all the way up to the nation's highest court for a final, binding decision. This was it.
After years of debate, testimony, and all that deliberation, the moment of truth finally arrived.
And by a vote of 10-4, the Supreme Court sided with the giant. PLDT had won. The court officially blocked ETPI's application to build its own international gateway. Now, that vote was pretty decisive. But those 4 dissenting votes, they signaled a deep, bitter controversy simmering right there within the court itself.
So what was the majority's logic? Well, it was based on a core legal idea, that public franchises have to be interpreted strictly against the company holding them. They basically said, look, telephones were not some new invention in the 1950s. They were around when the original franchise was written. So since the law could have mentioned telephones, but didn't, the court decided they were intentionally left out.
But oh, the dissent fired right back, calling the decision profoundly flawed. They warned that this ruling wasn't just about ETPI. No, they said it was a danger to the entire principle of free competition and would only end up protecting and expanding PLDT's monopoly in a sector that was absolutely vital for the country's development.
And that right there brings us to the real legacy of this case. Because what it did was perfectly capture this fundamental tension between protecting a powerful established monopoly and, on the other hand, encouraging competition for the future.
Let's just break down the 2 philosophies that were at war here. On one side, you have PLDT, arguing that a monopoly is good because it avoids wasteful duplication and it protects the huge investments needed to build a national network. But then you have the challengers, ETPI and the National Telecommunications Commission, arguing that competition is absolutely essential. It creates backups to prevent massive outages, it drives innovation, it lowers prices, and maybe most importantly, it stops one single company from abusing its power.
So, when you boil it all down, this case really wasn't just about phone calls. It was about the immense power of a monopoly. It was about how our legal system can really struggle to keep up with the incredible pace of technology. It was a fierce debate over what the public interest actually means. And, at its core, it was a classic battle between the literal text of an old law and the future-facing intent that was supposed to be behind it.
Which leaves us with a question that is probably more relevant today than it has ever been. When technology just leaps far, far beyond the laws that were written to govern it, what should guide our decisions? Do we stick to the letter of the old law, or should we be reinterpreting those laws to serve the needs of the future? This case might be from 1992, but that question, that's one we are still trying to answer today.